Hello everyone, welcome to Crystal Diaries. This is another video of a series of videos relating to law of contracts in India. And in this video, we are going to learn about performance of contract. By the way, this is only the part 1 of performance of contract. The other part shall be uploaded after a few days. So, performance of contract. Before we begin that, please, as I always say, please bring your Bayret, a notebook and a pen. Why? Because we can read the Bayret simultaneously and note down every important point that we discuss in this video. So without any delay, let us begin. So section 37 says about obligation of parties to contract. So the parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provision of this act or any other law. Promises bind the representative of the promiser in case of death of such promisers before performance unless a contrary intention appears from the contract. Okay, so we are going to understand this concept. So, what is a contract all about? A contract is about promises. A party promises the other party to do an act in exchange for something which is called consideration. Similarly, the second party also promises to do his part of promise in exchange for a consideration from the first party. So what does it basically say? You know that every contract consists of reciprocal promises. Each party to a contract is bound to perform the promise made by him. So section 37 says that it is the duty of the parties to perform or offer to perform their respective promises. Now offer to perform is also termed as tender. Okay, they can tender or offer to perform their respective promises. But under two conditions, they are not supposed to perform or offer to perform their respective promises, and they are if such performance is dispensed with or excused under the provision of this act, means under the provision of the Contract Act or of any other law, which means that not only contract, but if there is any other law that dispenses with or excuses the performance of such contract, in such cases the parties to contract are not under a duty to perform or offer to perform their respective promises. Now the section 37 also says that promises bind the representative of the promiser. So when a person dies, in that case, if that person is a promiser, then the representative of the promiser will have to perform that contract. But this is subject to an exception if there is a contract or there is any contrary intention that is made in the contract, that if such person dies, the representative of the person shall not be responsible or shall not be liable to perform his part of the reciprocal promise. In that case, the representative of the promiser who died, his responsibility is dispensed with. And what is such kind of exception? If the performance requires personal skill. Now we are going to learn about this after a few while, after we complete the illustrations. See, the first illustration goes, A promises to deliver goods to B on a certain day of payment of rupees 1000. A dies before that day. A's representatives are bound to deliver the goods to B, and B is also bound to pay the rupees 1000 to A's representatives. So in this case, if here the promiser died, now the representatives have to perform the promise made by the promiser. Now the second illustration says, A promises to paint picture for B by a certain day at a certain price. Now A dies before the day. The contract cannot be enforced either by A's representatives or by B. So in this case, what happens? Now this performance required the personal skill of A. Okay. Now, since A died, his representatives cannot do it because it involves personal skill. So, since A was dead and none of his representatives could do that thing for him. Similarly, B's representatives or B is also dispensed with his reciprocal duty. Now, section 38. Coming to this, it says effect of refusal to accept offer of performance. Now, section 37 says that a person shall or the promiser shall offer to do or perform actually the reciprocal promise. Now, what if a person has offered or performed his part of promise, but there is a person who refuses to accept the offer of performance? So, section 38 says, where a promiser has made an offer of performance to the promisee and the offer has not been accepted, the promiser is not responsible for non-performance, nor does he thereby lose his rights under the contract. Now, if a person is offering to do something, now and the other person to the contract, he denies or he refuses to accept that offer, in that case, the first person shall not be responsible for non-performance. And that also does not mean that the first person has lost any kind of right under the contract. So, what exactly is offer of performance or tender? Now, the essentials of a valid tender are: first, it must be unconditional. Secondly, it must be at a proper time and place. Thirdly, promisee must be given an opportunity to ascertain that goods are according to the contract. And fourthly, an offer of performance to one of the joint promises is a valid tender. So, in many cases, you find there are more than one promisees. Okay. So, in that case, if the offer is made to any one of them, it is a valid tender. It is not necessary that the promiser shall offer to perform to each of the joint promisees. It is sufficient if he has tendered to one of the joint promisees. So now moving to section 39. Effect of refusal of party to perform promise wholly. When a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. So in this case, if a person is refusing to perform his part of promise wholly, in that case, the other party has a discretion to put an end to the contract. But if he has signified by words or conduct that he wants to continue it, then he can continue so. So let us understand this with the help of illustrations. The first being, a singer, enters into contract with B, the manager of a theatre, to sing at his theatre 2 nights in every week during next 2 months. And B engages to pay rupees 100 for each night's performance. On the 6th night, A willfully absents herself from the theatre. Now B is at liberty to put an end to the contract. Okay. Now the second illustration says, a singer, enters into contract with B, the manager of a theatre, to sing at his theatre 2 nights in every week during the next 2 months. And B engages to pay her at the rate of rupees 100 for each night. On the 6th night, A willfully absents herself. With the assent of B, A sings on the 7th night. B has signified his acquiescence in the continuance of the contract and cannot now put an end to it. You see here that when B absents herself on the 6th night, A had the right or B had the right or the liberty to put an end to the contract. But after that, B has taken permission for B has given permission to A to continue singing on the 7th night, and now B cannot put an end to it. But He is entitled to what? Compensation for damage sustained by him through A's failure to sing on the sixth night. Now the question comes, by whom should the contract be performed? Now this has been dealt under section 40 of the Act. It says the contract should be performed by the promiser himself if it was the intention of the parties. Okay, if they both have agreed to the same thing, that the promiser himself is to perform that, in that case nobody but the promiser has to perform the contract. And in other cases where the intention of the parties was not that the promiser should perform personally, he is part of the contract, then it can also be performed by his agents. Okay? Yes. Now let us discuss a very interesting aspect of this contract act, joint promisers and the nature of their liability. You may find that at times there will be more than one persons who have promised to do an act to the same person. Okay, so in this case the persons who have promised are called joint promisers. So when there is only one promisee and there are more than one joint promisers, let us understand what their liability will be and what will be the nature of the liability. So it says that the liability of joint promisers is joint and several. Okay, so the illustration will help you understand this better. A, B and C jointly promise to pay D rupees 3000. So in this case, since the nature of liability is joint and several, D may compel either A or B or C to pay him rupees 3000. So it is not necessary that he should compel three of them. Like he may compel three of them, he may compel two of them, he may compel one of them also. So since the liability is joint and several, so D is at liberty to compel either of the joint promisers. Now what if D compels A and A actually gives rupees 3000 to D? So will B and C not pay anything? No. There will be contribution between joint promisers. So in case A has paid the amount, he can recover the same from B and C. Okay? Each one will be giving 1000 rupees. Now there are two conditions. If there is inability of one of the promisers, so in case any of the promisers is unable to pay his part of payment, in that case the remaining joint promisers are to bear the loss in equal shares. Now let us understand this with the help of an illustration again. A, B and C are under a joint promise to pay D rupees 3000. Now C is unable to pay anything and A is compelled to pay the whole. Now in this case, since A has given rupees 3000, he should recover it from B and C. Now since C cannot pay it or he is unable to do so, now A and B will divide the share equally among themselves. So now 3000, if it has to be divided equally between two persons, that is they are A and B, then each one shall be given 1500. So A can receive rupees 1500 from B and nothing from C. Now another condition is that when some promisers are surety. So if there are joint promisers and one of the promiser is the surety, then he is entitled to recover it from the principal. Now this also we can understand with the help of an illustration. A, B and C are under a joint promise to pay D rupees 3000. A and B being the only sureties for C, C fails to pay. So basically C is the principal and A and B are the sureties for C, and C fails to pay. In this case, A and B are compelled to pay the whole sum, but A and B are entitled to recover the same from C. Now coming to another interesting aspect, the effect of release of a joint promisor. This is dealt under section 44 of the Act. It says that if one of the joint promisor is released, it does not imply that the other joint promisors are released as well. Also, it also does not say that it does not free the released joint promisor from the responsibility to other joint promisors. Now, another part is effect of death of a joint promisors on liability of others. So, what if there are more than one promisors, but one of them dies? Now, this situation is dealt under section 42 of the Act. So, in that case, the representative of the dead joint promisor will substitute him for liability. So, whatever performance was to be done by the dead joint promisor shall be done by his representatives now. And what if all of the joint promisors die? Then, in that case, the representatives of all of them must jointly fulfill the promise. But this rule is subject to an agreement to the contrary. And the same also goes for the joint promisees when the performance is to be claimed. And this has been discussed under section 45 of the Act. So with this, we complete part 1 of performance of contract. We shall be bringing the part 2 of the performance of contract shortly. Until then, keep revising and stay safe. Bye-bye.